You're in pain, your car is totaled, and suddenly you can't look anywhere without seeing a 1-800 number promising you millions. When you see those massive advertising campaigns, the immediate question is whether that firm will actually fight for your specific recovery, or if they are just going to process your injury like a number on a factory assembly line. The answer lies in how these lawyers actually get paid. Personal injury attorneys operate on a contingency fee model. They charge dollars up front, and instead take between 33% and 40% of your final settlement only if they win your case. Because that percentage is standard across the entire industry, the heavily advertised lawyer juggling thousands of files costs you the exact same out-of-pocket rate as an elite trial litigator. This chart maps out how law firms structure their businesses, showing the trade-off between marketing budgets and actual legal impact. Almost every generic firm falls into two extremes. Down here, you had high-volume operations known as settlement mills. Up here, you have boutique trial firms. Choosing who represents you means choosing one of these two business architectures, and the model you pick will directly dictate the final dollar value of your claim. A settlement mill operates on extreme volume. They spend tens of millions on marketing to bring in thousands of cases, prioritizing fast, low-friction processing over maximum payouts. Their intake is incredibly appealing. They offer 24/7 call centers, mobile apps, and instant signups. You can secure representation within minutes of a crash. But immediately after you sign that retainer, your file is transferred. You will likely never speak to the attorney whose name is on the door. Instead, your recovery is managed by a rotating cast of paralegals and case managers. You gain immediate administrative processing, but you lose personalized legal strategy and direct access to an actual lawyer. Because they handle thousands of active files, these firms rarely prepare cases for court. They negotiate with insurance companies by leveraging their sheer volume, looking to close cases quickly rather than threatening a trial. This creates intense financial pressure on you, the client. To turn a quick profit and move the inventory, these firms will frequently push victims to accept an insurance company's initial lowball offer. The high staff turnover at massive firms also leads to critical legal deadlines being missed. Severe injury cases are routinely dismissed entirely because a filing date slipped through the cracks of an overwhelmed case manager. A settlement mill operates as a volume-based marketing machine. By hiring one, you are trading the absolute maximum financial value of your case for the mere perception of convenience. A boutique trial firm reverses that model completely. They take on a small number of cases and focus entirely on the legal outcome. The operational difference is immediate. When you hire a boutique firm, you have direct, continuous access to the actual attorney actively building the strategy of your file. They approach preparation differently. Every piece of evidence is gathered and structured with the assumption that the case will go all the way to a jury. This creates what is known as litigation leverage. Insurance adjusters track exactly which lawyers take cases to court and which ones always settle. When an adjuster sees a trial firm on the file, they are forced to offer significantly higher initial payouts to avoid the courtroom risk. There are distinct trade-offs. First is the timeline. Building a bulletproof, trial-ready case requires accident reconstruction, medical expert depositions, and thorough discovery. It takes significantly longer than accepting a fast settlement. The second trade-off is selectivity. Boutique firms invest heavy capital and hundreds of attorney hours into each file. As a result, they actively reject smaller, less lucrative claims. Trial boutiques maximize the absolute financial ceiling of a claim. To get that result, you need to be a patient client with an injury severe enough to warrant their legal resources. Beyond the business model, there is a hidden financial trap built directly into the standard contingency fee contract. While 33% to 40% is the industry baseline, the actual check handed to you at the end of the case can be surprisingly small. This chart breaks down a TLO settlement payout. After the standard attorney fee comes out, shady firms will deduct undisclosed administrative costs, charging you inflated rates for basic postage, document copying, and preliminary investigations. You have to aggressively demand total fee transparency in writing. If a firm cannot clearly outline their out-of-pocket deductions, do not sign the agreement. Recognizing these traps is why so many people turn to online directories and review sites to find honest representation. But the local top 10 and best lawyer lists ranking at the top of your internet search are rarely objective evaluations. Many of these lists are pay-to-play marketing products. Law firms purchase these digital badges to establish instant credibility, completely disconnected from their actual trial record or ethical standing. Blindly trusting the fine print of a contract or shiny online badge is the fastest way to surrender thousands of dollars of your settlement to a mediocre firm. The free initial consultation isn't a sales pitch. It's a hostile job interview, and you hold all the power. If you were in a minor fender bender with no lasting physical injuries, a mid-sized regional firm is perfectly acceptable, provided their fee structures are explicitly clear in writing. But if your injuries are catastrophic or life-altering, you must avoid settlement mills entirely. Your recovery requires a trial-tested boutique firm with the capital to fight a protracted legal battle. To find the right firm, run every attorney through this strict 3-question framework during your consultation. Question 1, you must ask, who will actually handle my file daily? If the answer is a case manager, an assistant, or a paralegal, walk away. Question 2, what is your actual trial record for this specific injury? Watch for hesitation, vague success rates, or attempts to pivot the conversation right back to their massive settlement totals. Question 3, are there any out-of-pocket expenses or administrative fees charged to me if we lose the case? And remember your ultimate leverage in the process. In states like California, you have the absolute legal right to fire your current attorney at any time if you are being ghosted or pressured. A personal injury claim is a vital financial asset. Do not hire a marketing machine to do a litigator's job. Ask the hard questions, always demand full transparency, and ruthlessly protect your recovery.